on page 21, and its type copy is page 20. It was the stone that was transported was from Sonbhadra to Siddharth Nagar. Distance is also
Page 20.
page 20 is the type copy. And next page is the original one, where it has been checked back at the check post. The stamp, it bears the stamp.
It also admits that this is genuine.
And the police also admits that this is a genuine one. Only the Ford's one on which it was the driver took my name, that since I'm a truck owner, the dates were changed. My lord, may kindly say 15, 16, the distance is 357 kilometers. And obviously while coming back, he has played some mischief. And my lord, I'm a regular, I'm an income tax payer, and I filed in IABE where several such e-chalans have been filed, which have been checked properly.
It's possible for what your driver doing. You are the owner.
But someone, because the thing, because at the time gap between these two.
You are showing at page 20p2.
My lords. And the original one is that.
Valid permit.
Yes.
For carrying the minerals.
Yes.
Extracted minerals on 15th and 16th August.
Correct.
Yes.
And you are caught when?
They according to police, next day, 17.
So therefore you are using an old permit that must be the 17th.
I'm ready to cooperate, and offenses, all the mines and minerals are to be cognizance is to be taken on a complaint case. Now I will keep a check on the drivers, so install GPS or whatever it is, so that and the offenses, all the offenses are less than 7 years punishable.
While arrest of the petitioner shall remain still, subject to his joining and fully cooperating with the ongoing investigation.
We will cooperate.
He appears to be in a bit, because earlier also there is one more case.
My lord, that was not my truck. Yes.
Anticipatory, so is emboldened. Now truck you yourself will not drive, you will keep a driver. And
Because
every time you say, my driver has done it.
No, my lord, I will not do that. Truck has already been seized. It's lying with the police. I've suffered enough. So no coercive, my lords. I'm grateful to your lordship, my lords.
Lordship, I am in custody since 10th of June 2021. Lordship, High Court has dismissed my bail application on.
But what to do?
Yes, Lordship.
For a hardened criminal.
Lordship, but in this court itself has done that in the particular matter, the court has to consider the only case. And this case is only. Lordship, in the Prabhakar Tripathi, it was held that the court has to consider this case only. And in this case, Lordship, the complainant is the.
Every time the court must certize that how many offences you keep on committing.
Lordship,
while on bail.
Lordship, he is on bail in each and every case except the present one, and one more case is pending.
Therefore, there is a misuse of concession of bail.
Lordship, but the thing is that in this case.
Misuse of concession of bail? You get the bail?
Yes,
come
yes,
out,
Lordship.
commit another offence?
Lordship, but on that particular date, that the complainant himself was in the influence of liquor, he has outrated the modesty of the mother of the accused. And even if Lordship may see the photographs, the complainant is having axe in his hand, and he is knocking on the
302 to 397, 392. Where is the list of the cases against you?
Lordship, I have annexed that. I think parrot in that. But he is in bail on each and every case, Lordship, except the present one.
While you are on bail in a murder case,
Lordship,
registered against you in 2019,
Lordship,
that you are committing all these offences.
Lordship, then see the photographs which I annexed. It is part of this. The complainant himself. And Lordship, just allow me to read annexure P6. What is the observation of learned trial court? If Lordship may permit me, I will read it. P2 page 28.
Forget about trial court observation. The High Court has taken note of everything. High Court
Yes.
is aware of this principle.
Yes.
High Court says in this very case,
Yes, Lordship.
if you are granted interim bail,
Lordship.
you comes and commit another offence also
Lordship.
under the Arms Act.
Lordship, it was,
You are so much impulsive to commit crime. What can be done? You are a
Lordship, it is basically an entirely civil dispute, Lordship. He is the real uncle of the. Lordship, you permit me to read.
granted in jail there for 1 week.
Lordship, 3 witnesses have been examined. The main witness, that is the complainant, and his wife has been examined. And
How many are left?
Lordship, around 11 or 12 witnesses more.
So we will direct that in case trial is concluded within 6 months, fine. Otherwise, we will grant you liberty to move again.
Lordship, just read page number 66. Just read me the observation of the London trial court. What?
Don't go with the observation of the trial court. We are
Lordship, the trial court itself is saying there should be a cross case. It is entirely civil dispute. Even the I have annexed that.
Your conduct, which is recorded in para 70.
I agree with my contemporary that this case has to be considered. It is basically, Lordship, and there is widow mother and old age grandfather of the.
you are caught in CCTV camera where you are firing with an
Lordship, in CCTV camera.
unlicensed pistol or revolver, whatever you are carrying. You are caught on CCTV camera because otherwise you were denying. But then when you knew it that now you have been caught on camera, so therefore you can't.
Lordship, it
Now
was
you are
in.
building a story that he tried to.
Lordship, I am not building the stories. Even CCTV footage.
If at all somebody dared to do that, you should have taken. You can't take the law in your hand. You should have reported the matter.
Lordship,
Even
we have filed, but it has been
consequences.
registered as NCR only. Lordship, just observation of the trial court need to be considered once. Lordship. Page 66, last paragraph, Lordship.
We direct the trial court to conclude within 6 months. If they don't do it, then you move on application.
Lordship,
Having heard and consent for the petitioner that a considered length, we are not inclined to release in complaint at this stage. Also, when the prosecution witness as evidence has already commenced, into consideration the fact that case came to be registered in the year 2021. We direct the trial court to make an endeavor to conclude the trial within 6 months, subject to the cooperation 6 months, consult the petitioner, his counsel as well as the public prosecutor are directed to extend full cooperation to the trial court to conclude or conclusion of the trial in the time-bound manner. Instead, however, if the trial is not concluded, it is stipulated here for some unforeseen reason, liberty is granted to the petitioner to renew his prayer for bail.
Lordship, one more direction that trial could decide the case on his own merits. Trial court shall decide the case in its own merits without any prejudice with this order. Yes, Lordship.
Goes without saying that the trial court shall not be influenced by the observations made by the High Court in the interim order while deciding the main case on merits.
Please. Like this is the Tamil Nadu ED officer's case, Your Lordship. I've moved a small modification.
You are glad to visit this case.
Lord, I have no difficulty. My lords, in the order itself has granted liberty to visit. He could have moved the trial court, my lord, to get the permission. I don't know. Till Diwali, let him go. Let these matters may be listed, not for hearing, because that issue needs to be decided. I have no difficulty.
That of course decide.
Lordship said posed a condition that with
We are only concerned with this minor issue.
So, Lord, let him. I have no difficulty. He may go and visit.
Applicant frequent advertising and same consequently. State. Committee undertaken 20th March 2024. Modified stroke clarified. To the extent that Krishna is permitted to visit.
Lord, it should not be Madhya Pradesh. It should be either Bhopal or Sanchi, where his wife is posted. It should be a specific place, Lord. It
may make it Bhopal.
Bhopal, maybe Bhopal.
But where is the problem of Madhya Pradesh?
Lord,
Suppose his in-laws are there at some other place, the sister is other place, he can go there, what is the problem? In Madhya
Lord,
Pradesh.
in application, he has prayed for only 2 places. That is why I said.
So like,
In application.
why he has gone to Bhopal via Surya.
No, no one is saying that. No, I would have otherwise opposed this application.
How does it Bhopal or Indore, how does it?
Because he has come out with a specific case for those 2 places. I was.
Madhya Pradesh. Family members. Stroke relatives. What is the next date in trial court?
My Lord, state the.
But there must be given some date.
No date was given. It was the investigation. We were about to file charge sheet when my Lord state that proceedings. We couldn't file charge sheet. So there is no proceeding before the trial court.
So how is there any date fixed by the trial court after 9th of November? How the petitions shall remain present before the trial court?
Deeply. Deeply.
And main case supposed to matter for everyone also there.
Deeply.
Great.
Please, madam.
Lordship, there are connected cases. I'm only concerned with the application, but your Lordships are posting the matter. There's one case by the ED against Tamil Nadu, and there are 2 cases. So all those 3 cases may come up.
Don't you have nothing to do with those cases? This IS one suspense.
Certainly, deeply.
Please, my lord. My lords, in this matter, my lords, the learned single judge had decided the writ petition in my favor and had dismissed the writ petition. And my lords, in appeal, respondent. My case is completely covered. DSB.
Notice, she notice returnable on Saturday. Meanwhile, official of that's the agreement of the High Court in LPN number 574 of 2022 shall remain stay.
Obliged. Delay in refiling may kindly be done. Obliged, my lord.
May it please, my lord. Lordships, in this matter, this is the Bihar Panchayati Raj matter, Lordships. We are here for the Pramukh who's. Yes, Lordships. Lordships, in this case, in fact, there was no challenge to the first motion. And that first motion failed, and the applicant before my lord, she was successful. Now, Lordships.
Notice returnable on 5th November 2022.
Lordships. Lordships, in fact.
Commercially shall be justice well.
Notice.
Still notice as well. Tag related by simple numbers 1 Now, what is the problem here?
Lordships, in fact, Lordships, now a notice has been served.
No confidence motion.
Yes, Lordships. On 19th, Lordships, on 19th October that has been served, Lordships. The notice has come on 19th October and it is for 28th October. Therefore, Lordships, we were traveling. In fact, that first motion took place in January, not challenged, Lordships. Deeply obliged.
Notice of the second no confidence motion moved against the petition shall be taken in the meeting scheduled to be held on
28th
October 24
Not.
or any such or the meeting or any meeting that will fix thereafter.
Deeply obliged. Lordships, one small request. Lordships, the some of the respondents in the main petition, those two orders challenged, the pro forma parties, if they may be deleted for service purposes, Lordships. Lordships, it is respondent number 6 to 27 in the first impugned order and 8 to 48 in the second impugned order. Lordships have been pleased to pass similar orders.
We don't know.
Private respondent.
For the petitions that they run for the petitioners state that
Private respondent.
as per the instructions, so for respondents are performed only.
Lordships.
C6, the service of these respondents is therefore discussed with at the risk of responsibility.
Lordships. Most grateful. 6 to 27 in the first. Lordships, I'll give in writing. Lordship, there was no High Court proceedings in this matter. Grateful, Lordships. Most grateful.
Only notice, that 21 days. There is no delay as far as 24 full bench is concerned.
No, Lordships. Most grateful, Lordships.
Lordship. Here, Lordship, the Honorable High Court, the election tribunal allowed the election petition and directed the recounting. And the Honorable High Court even this case came up to this Honorable Court at the instance of respondent number 1. Your Lordship dismissed their petition. And final order, recounting was done. In recounting, the petitioner herein secured the highest votes. Now he was declared winner. And the High Court set aside saying that the election tribunal doesn't have jurisdiction. Lordship, this...
No, but just see, this order passed by this election tribunal. What a funny order has been passed. How can this order sustain?
Lordship, please kindly see.
This order is reproduced page 6 by the High Court.
Lordship, page 6 by the High Court. Yes, Lordship, page 6.
See, what is the reason, single reason assigned in the order?
Lordship, that order is operative portion of the order. Lordship, entire order is here. Lordship, kindly see. Now, page, original order is at page...
Original order.
Lordship, page 116, T10. Now see, issue was framed at page 125. Issues were framed by the election tribunal. 125. And thereafter, the election tribunal decided and hold finding. Lordship, kindly have the finding page 133. Even the counting agent of the petitioner was removed, was arrested from there. Lordship, 133, para 2, based on the above consideration. A detailed order, Lordship, has been passed by the election tribunal. And thereafter directed the recounting should be done, 134, on 23rd of September 2024, on Monday in the...
You are making all these allegations against the lady. How could she hijack or...
Lordship, members, Lordship, everybody was there. Even the statement was recorded. Everything was done. It is not that the election tribunal has passed just a cursory order. Entire evidence was considered. Both parties laid the evidence. Thereafter, election tribunal decided it. And Lordship, this case is entirely covered by the order, similar order passed by your Lordship, arising out from the order passed by the Chhattisgarh High Court at page 1, or can you see 158.
That every case has its own facts. What is
This,
are you referring?
Lordship, this case also, the election tribunal considered entire evidence. Even the statement of both witnesses were produced, recorded, and thereafter the election tribunal came to the finding that this is well-reasoned order, Lordship. And the High Court just producing one paragraph that this is the order passed by the election tribunal. The High Court has not put the reasonings given by the election tribunal in the impugned order. Lordship, kindly have. And 2 times, even the High Court directed the election tribunal to decide in 6 months. Earlier, the respondent number 1 was delaying the matter. Again, they filed a writ petition in the High Court. Against that order, they came here. And your Lordship dismissed their petition. A recounting was done on 23rd. It was informed.
Where SLP was Lady Kehkashan's SLP.
Yes.
8690/2023. That
Yes.
was dismissed against which order?
Lordship, kindly have this order. Lordship, kindly have this order. This is the order since they were challenging. They filed a writ petition saying that they have not annexed the challan with the election petition.
No. Which order of the High Court was
Lordship,
challenged in the SLP?
Lordship, this is the order. Lordship, that order was not initially with us. This is the order. Lordship, Lordship, (126). This is the issues. (162). Yes.
High Court's reasoning of that there can't be recount. A very obnoxious kind of view.
Lordship, the High Court.
The election tribunal can't order recount. Then what for the election tribunal?
Your Lordship, that election petition was decided without issuing notice to the other parties, my lord. So High Court has only redirected to hear the matter after issuing notice to everybody, my lord. And matter listed on Friday, my lord. Yes, my lord.
But not heard by the election tribunal.
Your Lordship, I have been heard, but other parties are not heard, my lord. There is a 9 respondent, my lord.
How are you concerned about other parties?
Your Lordship, without issuing, I am not concerned, my lord. I am concerned with me, my lord. So I have been successful, my lord.
As far as you are concerned, you
Yes,
are
my
heard
lord.
by the election tribunal.
Yes, my lord. I have been heard, my lord.
You are declared elected
Yes, my lord.
in this election
Yes, my lord.
because according to the returning officer,
Yes, my lord.
you got 664 votes.
Yes, my lord.
He got 658 votes.
Yes,
That
my
is the original question.
Yes, my lord.
Right? He goes in election petition. You are heard in the election petition.
Yes, my lord.
And the election tribunal says, oh, like recount,
Yes, my lord.
where the margin is very thin and there is a close contest between parties.
Yes, my lord.
Yeah, many times we have said a recount is always justified in such type of case.
I agree, but my lord, I am not coming in the recounting, my lord. The matter has been restored and it is fixed for hearing day after tomorrow, my lord.
Forget about
You will-
it.
Yes, my lord.
Today you were the successful candidate.
Yes, my lord. Last 4
Your
years.
election was challenged.
Yes, my lord.
Recounting was ordered.
Yes, my lord.
There has been a recounting.
Yes.
Now you are number 2. He is number 1.
Now he has been declared,
What right of the others is being affected by this?
but my lord, without the ballot paper, it was not produced before the High Court, my lord. They have not seen, my lord. Actually, I have not seen the petition. What ground they are taking, my lord.
High Court says others were not heard. That is why it has been sent back.
Notice was not issued to them, my lord. That was the reason, my lord.
This court and saying that we are affected.
Your lordship may,
As my brother is pointing out, they were not before High Court also. They are not before us also.
your lordship may,
So why the High Court is espousing the cause of someone who is not aggrieved?
your lordship, the problem is, my lord, I have not seen the SLP, my lord. I have not. Yes, my
For
lord.
what purpose the matter is now listed day after?
It is listed for re-hearing and deciding a fresh, my lord, as per the law laid down by the UP Panchayat Raj, my lord. Yes. There is 2 judgment by the High Court of Allahabad, my lord.
Here the now election tribunal will hear day after.
Yeah, same
SDM, my lord.
presiding,
Sub-divisional
same presiding
magistrate,
officer.
Earlier also recount was done by the same,
Yes,
in which you succeeded.
yes.
All right. Is there any problem if we direct that day after, nothing, no hearing, only recount will take place again in presence of the parties and no result will be declared, it will be produced before us,
Lordship, please, I don't have any.
I don't have problem, my lord.
right?
Let's do
That,
direct.
I
Yes,
think
my
that will be the safest way.
Yes, my lord.
And under the CCTV camera, otherwise, under the camera, counting under the camera.
There, of course, we will get it recorded. Why don't both of you are since in luxury litigation? We can appoint a court officer also.
Lordship,
Court commissioner will go there in his presence, let the counting take place. We will have rather more transparency.
Lordship, please. Lordship, please.
Where is which is the place in Uttar Pradesh?
Muradabad.
Mohammadpur, Chandausi.
Rajasthan is not far away. It's not.
Yes, my lord.
Yes. Sambhal.
Chandausi district, Chandausi, my lord. This is district Chandausi now, my lord. It is earlier Sambal.
Tehsil, Chandausi, district Sambhal. Moradabad.
District Muradabad.
Yes, my lord.
Chandausi is probably some industrial town there.
Chandausi is Tehsil, my lord.
Huh?
Chandausi is Tehsil and Sambal is district, my lord. District Sambal.
Not far away from Muradabad.
No, my lord.
It is separated from Moradabad itself.
Chandausi is known for some conventional small handicraft industries or something this area.
I think that is the
Unless,
calm.
of course, now all of them are busy in politics. Then it's a different issue. Because then say the petitioner, write down. The petitioner and the first respondent contested election of Grampradhan of village Mohammadpur, Kashi. Chandausi subdivision.
Yeah, Tehsil. Subdivision. Tehsil.
Tehsil Chandausi
Yes.
from a Sambhal, district Muradabad.
District Sambhal.
District Sambal now.
Tehsil Chandausi, district Sambhal. The election was held on 29th April 2021. Respondent number 1, test Srimati Kashi was declared elected as she secured 664 votes as against 658 votes counted in favor of the petitioner. the petitioner, the aggrieved petitioner filed an election petition, filed election petition number 4085/2021 on various grounds. His petition was allowed to the extent that the election tribunal directed recounting of votes, was allowed a wide order dated 9 September 2024 to the extent that recounting of votes was directed to be ordered to be to the extent that the tribunal ordered the recounting of votes on 23rd September 2024. Article number 1 challenged the order of the election tribunal in a writ petition before the High Court. The writ petition came up for hearing on 23rd September 2024, that is the date when recounting was to take place. It seems that the votes were actually recounted, in which the petitioner secured 660 votes, whereas respondent 1 was held to have secured 657 votes. Consequently, the petitioner was declared elected. Next paragraph. The High Court on the same day, by the impugned order, has set aside the order of the election tribunal, as according to the High Court, the election tribunal could not pass an order of allowing the election petition and at the same time directing the recounting of votes. The matter was consequently remanded to the election tribunal to decide the election petition afresh in light of some decisions of the High Court which have been cited by the learned single judge. Next paragraph. The petitioner has laid challenge to the High Court order primarily on the ground that recounting has already taken place and he has been declared elected. Respondent 1 is also present in court, is on caveat and is present through her counsel. Next paragraph. After a brief hearing, counsel for the parties have agreed to the suggestion given by this court that let there be a fresh recounting of votes in the presence of the court commissioner that will be appointed by us. The election petition is now listed on remand. The election petition, on remand, is now listed on day after.
25th, my lord.
25th.
On 25th October 2024. We thus direct the election tribunal cum subdivision magistrate Chandausi, right?
Yes.
Chandausi. So consequently, we stay the order of the impugned order of the High Court to the extent direct that the election petition be decided afresh as per the observations made therein, and rather direct the election tribunal come SDM Chandausi to conduct a fresh recount of the votes in presence of the court commissioner on the date fixed, that is 25th October 24. The entire recounting process shall be videographed. The result on recount shall be signed by the parties, their counsel, as well as the court commissioner, besides the presiding officer of the election tribunal. The result, however, shall not be, next paragraph, the result, however, shall not be formally declared, and the entire original record, along with the report of the court commissioner, shall be produced before us on so and so date. On so and so date. We keep on 6th November, Wednesday, on opening 6th November. So, next paragraph. Till the next date of hearing, responder 1 will continue as Grampradhan, but no decision having financial implications shall be taken by him. That's all. So 6th November, now the court commissioner shall be paid. How much? He will pay, but can't ask a lady to pay. Hats off for that.
Lordship ultimately says Pradhan.
The family agreed and she is contesting election. That itself is a great compliment and initiative she has taken in this belt and where she has decided. So we don't want to burden her. You will pay the
Lordship. Whatever your Lordship may decide.
This will be 20,000. कोई यंग से बच्चे को कोई देखो ढूंढ के कोर्ट कमिश्नर को यंग बच्चे most present. Who is the junior most present here? Whose license is 1 month old, 2 months old, or 3 months, or 1? No, girls, ladies. We will indulge in discrimination. This privilege is only for the young ladies. So who is the junior most among the ladies? Oh, very good, very good, very good. So you will go there. Right? You will go. And 5,000 for conveyance.
Lordship, please.
You take a safe cab, go there, and to the registry directly to communicate this order to the election tribunal from sub-regional magistrate Chandausi during the course of day, along with the mobile contact stroke mobile number of the learned court commissioner. The SDM Chandausi will coordinate with the election with the court commissioner and ensure that the recounting commences only after she reaches the court, the official complex where the recounting will take place. The parties through their counsel will also remain present. Are you there free on Friday? You can go on 25th.
Friday is a working day. You can go on Friday.
Go. Who is your senior? I will direct him to exempt you. So allow her to
Yeah,
go.
allow her to go.
Yes.
Not 5,000 will be too less to and fro. From here to my 200.
Nowadays,
5,000.
5 more. Maybe.
It will be more than that. Far more.
10,000, man.
10,000. You pay 5,000. 5,000 I will pay. Lordship, he has approached this court up to this court 5 times. He contested up to the High Court and Supreme Court. He is very financially very strong.
For conveyance, we fix 10,000, 5,000 you will pay.
I will pay, my lord. 5,000, no problem. I will,
Yes.
I will pay, my lord.
For conveyance, 10,000, 5,000
Yes.
to be paid by
Yes,
the
yes.
fiscal
5,000.
levy.
Your lordship had directed to council to be remain present there. Council, local council, or ourselves?
Council, local council.
Local council.
Local council.
Yes, local council.
Local councils are there. The Deputy Superintendent of Police, Chandausi, is also directed to make necessary arrangements for the peaceful conduct of the recount and to ensure that law and order is duly maintained. The Deputy Superintendent of Police will also ensure the safety and security of the court commissioner, and if need be, a lady constable shall be deployed to accompany her even from Delhi to replace it. If you need any lady constable, we have directed them that she will be there with you.
I don't know. I don't think she require any. She is the lawyer of Supreme Court. She is capable, my lord.
And make sure that all the proceedings are signed by both the parties.
Draw the minutes.
Draw the minutes there, then they should sign, and their advocate should also sign, and the presiding officer will also sign.
And if anybody refuses, take the name that so and so has refused to sign.
Yes.
We will accept your version. You are acting on our behalf. Right?
And all SDM or DSP or anybody else, they are supposed to follow your command because there you are our delegate.
Yes.
And deeply, my lord.
Highly.